It's not what you do when you get put on the canvas. It's how you get up and how you fight. And that's what we're watching with another Profile in Courage chapter by Judge Hannah Dugan, who, yes, got indicted yesterday in the Eastern District of Wisconsin in a one-way railroading indictment by the Department of Justice under Trump. But today is a new day, and the sun rose, and her lawyers filed a motion to dismiss, claiming that she cannot be prosecuted or indicted. She can't be convicted because she has, wait for it, I'm going to use the I word, she has immunity. And guess what case she cited in order to support her argument? You're right, Trump's immunity decision. Oh, sweet poetic justice, cosmic justice coming to fruition. And shout out to the lawyers for Hannah Dugan for not waiting around until the arraignment on the 15th or tomorrow, where she would be arraigned on the new criminally indicted charges. The indictment would be unsealed. So they got ahead of it with the motion to dismiss, which I like a lot. I'm going to cover it right here on Legal AF. Hannah Dugan, I won't bore you with all the details, but you know what happened. You know, she is a criminal court judge presiding over cases and dockets in her courtroom, in her courthouse in Milwaukee. And on one fateful day, on the 18th of April, she had before her a particular defendant on an assault case, a guy named Flores Ruiz. Mr. Ruiz, or Flores Ruiz, has apparently got another problem related to immigration. So Immigration and Custom Enforcement, ICE, federal officers figured out through the database and the way he was being transported that he was going to be in court with Hannah Dugan. Okay. So then call ahead with Hannah Dugan. Make arrangements to pick the guy up either on the way into the courthouse or on the way out of the courthouse after he's done with a metal detector. Well, what you don't do is what they tried to do on the 18th. You don't come guns a-blazing, metaphorically, six members of the federal, task force and ICE all showing up, coming heavy into the state courthouse. This is federal versus state now, and just set up outside and to pick him up. And she said, "What is going on here?" Defending the rule of law, defending the administration of justice. She alone has control over her courtroom and by extension, the courthouse. She told them to go talk to the chief judge. In the meantime, she finished her hearing. She did whatever she was going to do with that guy, and she sent him on his way. They didn't like that, and they charged her with obstruction and in something called concealment in a criminal complaint. Another reason she sent them away, as we know, is that they had in their hands not a judge's issued arrest warrant. They had an administrative arrest warrant from ICE. And we can't trust this administration. And Judge Dugan was right to turn that away. But a week later, rather than have her self-surrender on a criminal indictment, they went down to the courthouse and perp walked her and put her in handcuffs. Because the Trump administration wants to retaliate against state court judges, against the judiciary, and make a mockery of us and make an example of them. And so that happened a week later. And then they had to move that criminal complaint into an indictment. And they got, after a full day of grand jury work yesterday, they convinced the majority of 20 grand jurors to side with the prosecution, at least for now. Remember, though, in a grand jury proceeding, there's no defense, there's no defendant, there's no cross-examination, nobody testifies on behalf of the defense, no evidence is put on behalf of the defense. So you can see why you can indict a ham sandwich, as the old joke goes. Now, Hannah Dugan, Judge Dugan, had a choice. She could just, what we thought she was going to do tomorrow on the 15th or so, was to show up in court in the front of the magistrate judge and plead not guilty. They would set bond, probably would be very low or nominal, let her walk out the front door, and we move on in the case. I said in a hot take I just did over on Legal AF about this matter, and here on Midas Touch, I said I believed that very, very quickly, today, tomorrow, I literally said today, tomorrow, there would be a filing for a motion to dismiss. I was using as my example Mayor Adams in New York, almost within hours of his indictment. They had like a 30, 40-page motion to dismiss. So they did it. They did it within hours of the indictment. They filed the motion to dismiss. Now, let me preface it by saying, and I'm going to post it on the Legal AF Substack, where you can get all these kind of documents. I don't believe this is the final word from Judge Dugan. It's skeletal. It makes the right arguments. It's only 7 pages. I think they're going to have to do better. I also scratch my head a little bit about where Paul Clement, the former Solicitor General under George Bush, who I had heard joined her team, but I don't see his name on this filing. Maybe he's working on a bigger brief. But here's what they say. They say there's 2 major reasons why Dugan cannot be prosecuted and certainly can't be convicted. It's because she has immunity as a judge. She has judicial immunity for all official acts as judge. Okay, so that argument is based on Trump versus the United States. That early on in the case, like now, before we get any further, a court has to make a decision about immunity, separation of powers, and the like. And what their argument is that since she's allowed and she's empowered to control her courtroom and her courthouse, that her telling the ICE officers to wait out here and sending the guy out another door into another public hallway, that was all part of her administrating her justice and the rule of law in that courthouse. And you can't indict her for that, citing Trump. They also cite to the 10th Amendment, which is not often cited, but it's interesting. To remind you or to tell you the 10th Amendment, it shows it's the core of our federalism system. It says that what powers will be reserved to the states after the feds take the power that they want to take. In other words, federal power is federal power, but whatever they don't take as federal power in a certain subject area is reserved for the states. It was a way to compromise with the states who really didn't want to necessarily join together in the United States of America with a federal government and a state government. And what they were told was, you'll have states' rights up to the limit of whatever the federal power. If they don't step in and oust you from that, you have all of that power as a state. And it's very relevant, as they cite in their filing, which I'm going to read to you in a minute, because 99.6% of all criminal matters in America are prosecuted in state courts. And so they're saying she's a state court judge in the criminal area. Federalism and the 10th Amendment says, back up. We have the power, not you. States' rights, not you. Home rule, not you. Combine that with judicial immunity. This thing should not take that long. And this will be considered by a magistrate judge. I think he'll ask for more briefing on the issue. Maybe we'll see Paul Clement appear again. But here's what they say on the first couple of pages of their motion to dismiss. Honorable Hannah C. Dugan moves for an order dismissing the indictment. This is no ordinary criminal case, and Dugan is no ordinary criminal defendant. The government's prosecution is virtually unprecedented and entirely unconstitutional. It violates the 10th Amendment and fundamental principles of federalism and comity reflected in that amendment and in the very structure of the United States Constitution. She's also entitled to judicial immunity for her official acts. Immunity is not a defense to the prosecution to be determined later by a jury or court. It is an absolute bar to the prosecution at the outset. See Trump versus United States from 2024. She then goes on to talk about the immunity that she's entitled to have. On page 3, she says, judges are empowered to maintain control over their courtrooms, especially in the courthouse generally. The issuance of an order removing persons from the courthouse in the interest of maintaining such control is an ordinary function performed by judges. And they also remind the court that the subjective intent of Dugan, even if there was subjective intent, is irrelevant when it comes to an immunity analysis, again, citing to the Trump case. So what's going to happen next? Indictment happened. Arraignment is still going to happen tomorrow. I'll cover it. She'll probably bond out, bail out, or not have any bond or bail set against her. She will then have to, the case will then take on a new dimension. The judge, though, is being asked to consider right now upfront immunity and not let any other part of the case go forward. Otherwise, she would normally get a whole treasure trove of defense material. She'd get the witness statements the government has. She'd get all the grand jury sealed secret testimony from the grand jury proceeding. She'd get any documents and the rest as they develop their own defense case. And then they could refile the motion to dismiss at a later time. But I think they wanted this out there both procedurally to talk tough, to show that they're in this to win it, and to put the government back on its heels. I don't think, though, this is the last paper. I would be shocked if Paul Clement is still involved with the case as the Solicitor General under George W. Bush, a right-wing icon. If he's still involved with the defense of the rule of law and Hannah Dugan, we're going to see a much better filing by him. But I guess maybe this reflects there was like an internal fight with the Dugan team about speed versus quality. I think this is okay. I mean, not to be a jerk about it, but this is okay. This is not as amazing a piece of legal writing and advocacy as I'm sure the team could do given more time. So I'm sure we'll see another filing, and then we'll cover it right here. Now, you're already on Legal AF. Subscribe. Come on over to Legal AF, the Substack, where I post this motion to dismiss, and you can see it for yourself on Substack, along with a morning briefing that I do over there called Legal AF. We post all the filings, which I call Filings AF. We're very consistent here. And then, of course, we've got the podcast Legal AF as well. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.